Cowan pithily quoted from the Northland sovereignty discussion, ending with the tribunal's comment that chiefs and Māori would be equal. Now, the question of equality is something that I find difficult to understand in an 1840 context, both in terms of the Māori world and in terms of the European world. And I mean, we are in this house, and I've been absorbed by the fact that we are here because in 1950 a group was elected to this house who were known at the time as the Suicide Squad, to take away the sort of last vestiges of aristocratic government in terms of New Zealand. Some would argue that the Māori statutory authority in the Auckland City has re-established some of that aristocratic government. But I'd like to start by taking us back to the treaty itself, and I'm going to read from Colenso's account, not his published account, but the actual manuscript that he produced at the time. And I'm going to actually read something that has absolutely no relevance whatsoever to any judgment that's ever been made on the treaty. And he describes the scene. In the midst, Sot Hakitara, a tall native of the Rarawa tribe, dressed in a large, handsome white mat with very deep coloured border, the whole of native manufacturing. The light streamed from an aperture in the top of the tent on this beautiful white garment, made the figure of this chief to be very conspicuous, at the same time forming a fine contrast to the deep shades around. Whilst here and there was seen a honey adorned with flowing white long hair and crimson cloak and feathers. In the distance, the raven black heads of the native ladies, gracefully adorned with the snow-white drooping feathers of seabirds, formed a striking contrast. This is not an egalitarian society, a society that demonstrates its status by dressing up is a society where mana and status are differentiated. And that differentiation and that difference between iwi has been something that has caused an enormous difficulty for the Crown, and I would suggest for almost every other institution that the Crown has established, including the Waitangi Tribunal. The Waitangi Tribunal in its Northland report identifies problems in the future, as Cowan's quotation readily identifies, should there be conflict between the settlers and Māori, but makes absolutely no comment at all on what would be the case should there be conflict between Māori. The assumption, popular assumption, that the Waitangi Tribunal deals with claims against the Crown has been difficult to maintain, given the extent to which tribal disputes, both inter- and extra-tribal disputes, have become a strongly dominant part of the Tribunal's work and a discourse that's carried into the negotiations themselves. Now, I want to actually contradict Bain quite substantially here by saying that historians do have a role using their pretty normative professional skills in assisting to deal with these disputes. But we have to actually be very, very careful about what those skills are and their limitations. In the 1980s, when I became part of the tribunal process, historians and claimants generally agreed that Māori history was the responsibility of Māori tribal historians. Only insiders could understand whakapapa as a form of history which animated and gave meaning to the Māori present, and built up on Māori cultural values, worldviews, and on Māori understandings of what made things happen. This particularly involved metaphysical aspects of what happened, aspects that were well beyond the normal repertoire of professional history. This demarcation, however, began to break down towards the beginning of this century. Now, I'd have to say that as a practitioner in the field, claimants were extraordinarily generous in providing researchers with whakapapa, with a known sense of their tribal identity. But after about the late 1990s, historians became increasingly involved in telling tribal histories. There are a number of reasons for this. One, I think, deals with the changing nature of the inquiries themselves. In the early tribunal inquiries that were faced on specific issues or specific events, although they were regarded as tribal claims, they were not regarded as comprehensive inquiries dealing with all aspects of tribal claims against the Crown. This changes with Ngāi Tahu and becomes even more even more consolidated with the development of the regional inquiry model in the middle of the 1990s. The reason that historians were brought in, or the reasons, first, the stakes just got so much higher for iwi in these inquiries. Iwi understood that if they were in, they had the opportunity to identify themselves, to identify their customary relationships with the land and their histories, and to do so first gave them a major advantage over others. And in many of the cases where certainly I was called in to work with iwi, it was purely reactive to claims that had already been made in the tribunal. And I was talking to Cowan about Tuhoi claims in relationship to Ngāti Kahungunu ki Wairoa that took us into Wairoa. There was another, I think, methodological reason why claimants turned to professional historians, and that was because of the nature of evidence that was required to be examined. Most claimants believed that they had the resources to tell their own story. And often that is certainly the case. But claimants not only wanted to tell their own story, they wanted to tell their own story in a way that was authoritative, in a way that would trump the stories of their neighbours. In turning to those stories, they had to deal with a monumental amount of paper. And I think this is actually one of the fundamental questions that Bain was talking about. Why historians? Well, one of the reasons is simply practical. In New Zealand, so much of the colonial relationship between the Crown and Māori has been put to paper. So for many iwi dealing with their claims against the Crown, there were literally thousands of pages of whakapapa evidence to be processed and to be analysed. And it just became overwhelming. So historians were called in to make the best case for what I would call whakapapa histories. And I want to just describe what I mean by whakapapa histories. Whakapapa histories are histories of identity based on genealogy. They tend to be flexible, but they tend to be specific, as you would expect. They tell often distinct stories about the same land. Very rarely do these competing stories share a sense of common boundaries with neighbours. They may well have stories of boundaries, but they're very rarely the same boundaries shared in the same stories and interpreted the same way across the different stories that discuss them. In some cases, these stories talk about battles. Winners claim victories, but so do the supposed defeated. Battles that are decisive may or may not be followed up with conquest. One of the most delightful claims, well, it's not delightful because it's a particularly difficult event, is Michael will be well aware of Te Pawoho's raid in 1836, where a group of Northern Māori travelled down the west coast, got within about 11 miles of current Invercargill and were all slaughtered. And in 1853 or 55, Ngāti Toa sent a claim into the Crown saying they claimed all of that land to that point because after their chiefs were killed, not a cricket was heard on the land. The Crown's response was to say, it's a very unusual claim, and to ignore it completely. If we actually acknowledge that these contested histories are fundamental to Māori resilience, Māori identity, they are statements of right, they are statements of both the past and the present, but they are not fixed at 1840. They are flexible, changing, they reflect histories prior and after 1840. And yet so often, when dealing with these histories, there has been a major attempt to adjudicate between them, to decide which history should prevail over another. And this is the area that I find particularly difficult. Historians have often been, and I have been one of them, commissioned by specific claimant groups to tell their story, which allows historians to actually give a degree of professional weight, particularly by being able to show that the whakapapa evidence being presented in the present has echoes in ancestral voices in the past. The difficulty is that when these professional witnesses simply spar off against each other, they tend to follow an assumption which Alan Ward to some extent and Angela Ballara to some extent have followed, that good history should be able to decide. The use of independent historical technique should be able to work out what happened. Now, in my experience, this is almost never the case. In some cases, it is possible to discount various statements made in whakapapa history, usually because they're outlandishly exclusive, and it's not too difficult to show that other people were there. But in most cases, the historian is left with two competing stories. And I would suggest that the judge of the Māori Land Court or the Waitangi Tribunal is faced with those exact same situations. So much of colonial history in New Zealand to the present has been attempts to adjudicate between those stories. And I would sort of raise concerns about historians being too strong advocates for one position or another. What I do think that historians can do is to pull apart that historical evidence to show the existence of these different competing historical narratives, these whakapapa histories. Having shown that these histories exist, and in some cases, and there's one particular claim before the courts at the moment, where the historical evidence shows no existence whatsoever of any whakapapa history with a certain resource that's being claimed. The historian's job is not to decide. But it's probably not the court's decision or the tribunal's capacity to decide either, since so much of these decisions really do depend on interpreting what the historians have to say. So I'll just finish there's one point I do want to sort of put to bed, and that is that there are rules about customary relationships with land and waters that can simply be tested. Rules of occupation, rules of ahika, rules of conquest, and that these can simply be used against these stories to approve or discount them. Now, most of you, but I suspect not all of you, would be aware that these rules were not manufactured by the Native Land Court in the 19th century. They were manufactured by the Native Land Court in the 1940s and imposed retrospectively and inappropriately over evidence that is far more confused, far more varied, and far more contingent on local circumstances. So in my view, and as we move from a period where these debates are occurring before the tribunal to what I would regard as a continuation of customary disputes in a post-settlement era, then I think it's really important that claimants actually, A, realise the limitation of the courts, the historical evidence, and even the tribunal to make such decisions, accept that such decisions are always going to be contingent and political, and set up frameworks themselves for resolving those decisions, whether that involves arbitration or some other process. It doesn't really matter as long as it's agreed and it is understood that this does not define forever the customary relationship between the groups involved or necessarily reflect in any substantive way some historic relationship between the 2, 3 or 4 iwi. And in this I have substantial faith in Māori pragmatism, negotiation, diplomacy, and ability to come to decisions where such decisions are required. The one problem with this as a historian that I would leave you with is that having made such decisions, there is a tendency over time for these decisions themselves to enter into the disputed whakapapa histories of those involved. So I've kept you from your lunch for long enough. Thank you.